Good afternoon, Mr. Clerk.
Conversation between you.
Present.
The Honorable Carmelita Gomes, District 2. The Honorable Helen Z. Willis, District 3.
Present.
The Honorable Joseph Sebastian, District 4.
Present.
The Honorable Corey A. Reeves, District 5. The Honorable Natasha Williams, District 6.
Present.
And the Honorable Linda McCure Pritchett, District 7.
Present.
And lastly, the Honorable Mayor Khalid.
Present.
Mr. Mayor, you have a quorum.
Thank you, Mr. Clerk. Go ahead and sound the first item.
The first item is second read and request council approval of an ordinance amendment to the 2021 comprehensive plan and future land use map to correct errors and omissions in the city's comprehensive plan. This is being presented by CDRA.
All right, Mr. Hall.
Thank you, Mr. Mayor, members of council. Derek Hall reporting on behalf of Community Development and Regulatory Affairs. The item before council is, as the clerk mentioned, a second read. Basically, this particular location was an error as it related to the designated land use. And so staff is respectfully requesting to change the land use designation from commercial center to industrial. And this concludes staff's presentation.
All right, I will, let me first say that the queue is open. I'm not sure if people are using the queue or if they are raising hands, but we do have the queue open. I see Councilwoman Willis's hand. Councilwoman Willis.
So, Mr. Hall, can you explain what's being changed specifically in the, it says this is a second read for the future land use map to be changed because there were errors. Can you specifically speak to the errors and omissions?
Yes, it just happens to be for this particular parcel, which is located along Fulton Industrial Boulevard. When the city was going through its process to identify the appropriate land use, this particular land use was identified for commercial center, but everything around it to the north, south, east, and west wasn't. So it may stand out as a standalone land use designation of commercial center. And so we're just asking that, and looking back at the notation of the community meetings that occurred, and then keeping in mind kind of the general area and the industrial nature along Fulton Industrial, we're just asking to change the land use to an industrial zone instead of commercial center zone. Land use district, I should say.
Okay, and this impacts only Fulton Industrial?
This impacts only this particular area. Councilmember Willis, I will be bringing forward, as we're continuing to go through the comprehensive plan and look at some land uses, I'm going to be bringing forward more of these types of land use changes, because as we kind of generally understood, when ARC took on this, some of the land use designations may have not been appropriately designated at the time. So this is just a matter of trying to correct something that we found out after the adoption of the comprehensive plan.
Okay.
I move that we approve the correction to the comprehensive plan future land use map.
Okay, you were done, Councilwoman Willis?
Yes, from my understanding, you're saying that this is just, this particular text amendment just focuses on changing the commercial to the industrial use, specifically for this Fulton industrial area.
Okay.
Correct. And as you all know, as a part of our comprehensive plan, in addition to having the narratives that we also have an accompanied land use. So in this instance, we're simply just changing the land use designation from commercial center to industrial.
Okay. Thank you so much, Mayor. Yes, I yield. My questions have been answered. I appreciate it.
No problem. All right, I will entertain a motion now. Dr. Rao.
Okay. I move that we address the technical correction as recommended by staff to update the comprehensive land use map.
Second.
It's been properly moved and seconded. Mr. Clerk, would you please call the vote?
The roll call vote, Councilmember Rao,
Yes.
Councilmember Gums,
Yes.
Councilmember Willis,
Yes.
Councilmember Sebastian,
Yes.
Mayor Pro Tem Reeves, Councilmember Williams,
Yes.
Councilmember Pritchett.
Yes.
That item was approved 6-0.
All right, please sound the next item.
The next item is item number 2 listed on your agenda. It's the second read and request council approval of a zoning ordinance text amendments to update the short-term rental and rooming houses regulations. It's a presentation by CDRA.
All right, Mr. Hall.
Yes, thank you, Mr. Mayor, members of City Council. Derek Hall reporting on behalf of the Community Development Regulatory Affairs Department. This particular item is an item that we have worked in tandem with the City Attorney's Office, and it's being sponsored by Councilwoman Willis as it relates to examining the short-term rental ordinance section and trying to understand how to better regulate these types of uses that occur in our community. So before you in the staff report, it generally talks about and provides the city's definition of short-term rental. And what should be noted as it relates to the definition as outlined in our ordinance is that short-term rentals basically govern types of activities that are 30 days or less. Now, we know that there are certain types of residential uses whereby property owners are subleasing or leasing out their properties for commercial purposes that may go beyond the 30-day provision. So in order to appropriately regulate this, we looked at the ordinance and determined that we could strengthen the section of short-term rental by now making sure that each request comes before this body and the Planning Commission so that we can understand the potential impact in the community. The short-term rental process as it is now is an administrative process. So it is approved by staff. It prohibits our ability to add conditions because of the administrative conditions for approving or disapproving the application. On the flip side, we had concerns that based upon our review of the ordinance, there was nothing in the ordinance that would protect against those types of rentals that exceeded 30 days or more, or 31 days or more. We had a provision previously that was called rooming house uses. And what we're recommending to make sure that we have it covered, the city is protected, and the city has a vehicle to review short-term rentals for 30 days or less, or rentals for 30 days or more, 31 days or more, that we reintroduce to our zoning ordinance the rooming house use provision, and we allow that to be located in zoning districts that are typically of multifamily types of dwelling units. So with this change in our analysis, it shows that we have now coverage that would allow for the Planning Commission and the City Council, whenever we have any of these requests for short-term rentals or rooming houses, before they can be administratively approved at the staff level, they have to go before those different bodies in order for us to assess the condition for which the request is coming in, meaning we will look at the neighborhood, we'll make sure there is appropriate distances between residential uses, and we'll make sure that there's appropriate infrastructure to handle what could potentially be residential uses that have a number of occupancies that are coming into the actual residential use. This is tied directly to the certificate of occupancy. And what we found out is prior to the issuance of a certificate of occupancy, the city does, for new construction, the city does an inspection. If the inspection is done with the intent that this is going to be for a single family occupancy, it brings into question the validity of that C of O. Because if the intent is for the property owner to use the property to have multiple people renting out rooms or renting the facility, we need to make sure that we have a vehicle that will allow us to have inspections, that's from the fire department, building inspections, making sure that we have the appropriate signage that alerts individuals who may or may not be aware of where the closest exits are. There are additional development standards related to ingress and egress. Certain standards related to the building code will require that there be a second point of access if each room is individually being rented out. And so, again, in conversation with our city attorney's office, the staff and community development, and both the planning division as well as the building division, in communications with our code enforcement department, and then looking at some best practices related to how to handle short-term rentals, we're offering this recommendation that we think will capture all the different types of uses and will ultimately allow for our hearing bodies, and in this case, it would be Planning Commission and City Council, to review the appropriateness of these new uses coming into the city of South Fulton. And so with that, staff concludes our presentation, and we have a resolution that was prepared by our city attorney's office that delineates the changes that we're making to the ordinance related to short-term rental and rooming house uses.
Okay, thank you. I do see in the queue Councilwoman Gums.
I have my hand raised in the Zoom. Thank you, sir.
So, thank you for the presentation in regards to this. I definitely wish I was included in this process because I was the original author of the short-term rental policy. I do believe that there is some things that we do need to strengthen. But as far as rooming houses, and I get that that is part of you all are incorporating that into the short-term rental, but anything over 30 days is not considered a short-term rental. So what I'm trying to figure out is because we put legislation in place in regards to the process of it being administrative, that they have to come and apply for a business license. They need to take all of the necessary steps as far as inspection and things of that nature. So are we carving out something very separate for just the rooming houses? Because if they have met the requirements for the business license for just the short-term rentals, I'm not sure. I mean, if it's just rooming houses, will that come in front of the council? Because the short-term rentals, I don't think necessarily we're able to pretty much say that these people can't do that. We're just asking them to get a business license so they can operate properly. So can you explain that to me as far as trying to clear it up and having to make these people go through an approval for business license? I get it on the rooming houses, but as far as short-term rentals?
Yes, ma'am. I'm happy to address that for you and the council. We've received a number of complaints, even related to our current businesses that are operating.
Excuse me, Mr. Hall, can you please be specific to Councilmember Gums, because this is actually my legislation, and can you be specific, because she's not understanding why this has come into play, and can you please be specific with her and let her know that we met with a whole community, and I think you need to be a little bit more specific so you can inform her of what's going on.
Sure.
Councilman Willis, I do appreciate your enthusiasm, but I'm going to ask if we could just go as we are recognized.
Sure. And Councilwoman Willis is speaking about a particular housing house that underwent a series of renovations and changes through my department. It was permitted. At the time that these new renovations occurred this year, we were not aware that the house was going to be used for short-term rental. It was never indicated by the applicant that was going to occur. We went through and did the appropriate inspections after the construction was completed. And then shortly thereafter, we started to receive a number of complaints from residents in District 3 related to the types of individuals that were coming and going at the house. And this is one in a series of complaints the city has received kind of overall, but this one in particular. And so because this particular project occurred and we had recently issued new permits, we later discovered that what was shared as a part of the building layout was not in fact accurate based upon an inspection that our code enforcement was able to conduct. And so in essence, living quarters and recreational space and storage areas had been illegally converted into sleeping quarters under the guise of it just being renovations. Now, one of the reasons why, Councilwoman Gums, we had to tie this to the rooming house use definition of our ordinance is because not all, as you know, not all short-term rentals go through our process. And oftentimes we're not able to capture them until we have the diligence of our residents to alert us of some nefarious activities or something strange about the particular type of activities in a neighborhood. And so this was one of those cases where the application came in as a renovation of an existing house. We got several calls related to what the activities were. We did an inspection and found out that what we assumed to be the case based upon the tip from the community was in fact accurate. We then went to the court to get an injunction to go in and do a formal investigation. and we found that in fact it was true. Now going into this, we did see locks on all the doors from the outside, and we did see numbers on the doors, which we thought was a little strange if you were just renovating a house for a single family. But when we were able to get the injunction and go in, code enforcement then recorded that there were individual sleeping quarters contained within the house. So in order for us to protect against that particular situation and others that have been reported in the city, we consulted a couple of other municipalities. We did an analysis of what we had in our ordinance. And to your credit and the credit of your colleagues, we did have a great starting point with the short-term rental ordinance. But because of the changing dynamics and how we have these new companies coming in, and they're sometimes stealth companies, they may present one thing, but they're different. We just wanted to make sure that the city council had the ability to start governing a little bit closer and regulating more closely the activities that are going on, because in many instances, they're creating conflicts in the neighborhood. So when people are thinking that they're moving into single family subdivisions, it turns out that the properties are now being leased on a daily basis. And there's a turnover of different people in the community. And that in and of itself, as you know, can cause great harm, great alarm as it relates to the safety and security and just the familiarity of who is living next door to you.
So, and Mr. Hall, I thank you for that. And what I'm trying to figure out again, in regards to, I know you all had to include the rooming houses into the short-term rental, but my question is, instead of changing, is there just going to be language that's just added that specifically addresses the rooming housing versus changing the entire legislation? Because we have the information in there about nuisance. We have a whole host application that lets us know where these short-term rentals are within our city. That's how we're able to set up, operations and things of that nature. I do think that there's some more due diligence that is needed on the code enforcement side. We've sent out letters, but I think the rooming houses operate a bit differently than the actual short-term rentals of those people that are being placed on, those internet sites and things of that nature. So I'm just trying to find the difference in that, to where it's not, we're not approving business license and everything in regards to the short-term rentals, because if they're doing that properly, then there's not an issue there. I think the biggest thing and the biggest issues is the rooming house. So I'm just trying to figure out the separation piece. And do we need to change the entire legislation? Because we do have that information about nuisance, how to report, all of those things are included in that legislation.
Yes, ma'am. And I think I can answer it I think this might be a better explanation in terms of how we want to address it. So it becomes kind of a red herring, if you will, related to the short-term rentals and the policies that we have. And the thought was that we have it as an administrative process, as you mentioned, but we needed to have or add a little bit more stringent requirements related to enforcement. So the challenge is, at the level that we have now, because of the administrative provision, we're not necessarily able to add a series of conditions. That only comes in when you have what I call discretionary items, and those are your change of zones, special use permits, and your modifications. So in this case, keeping everything on the books as it is related to short-term rentals, we're now requesting to have a special use permit. And the reason why we do that is that at the time many of these single family houses were built, they were built with the intent of having a single family there. Now you've changed the dynamic if you are now doing short-term rentals and you're having multiple families come through the neighborhood. And that also necessitates us to now look at the development standards. And maybe now you have to, even for a short-term rental, you may have to have some additional standards related to parking, landscaping, buffering of, neighboring houses. How close is this to the next house? And as you know, in your district and in all other districts in the city, there are certain neighborhoods that will not afford themselves to be good short-term rental properties because they're probably too close to the neighbor. And so kind of taking what was created, trying to figure out how to better regulate in the future, because, we're dealing with this evolving and ever-changing dynamic of family. And I think in the staff report, we call it shared living concepts. We have to kind of address it kind of a holistic perspective. And so if we just say for rooming houses that they will be subjected to a special use permit, but not short-term rental, then all of the requests we're going to get to come into the city will be short-term rental, even though they may be rooming house uses. So we're saying just for these purposes in advancing this discussion, let's make short-term rental and rooming houses both be subjected to special use permits, because the sheer nature of people coming in and out has now changed the dynamic of the neighborhood, of the immediate area of that particular house. And we may have to add additional development standards. We typically can't do that at an administrative level review. We can request the fire inspections, but in this case, as we were speaking about in the situation in District 3, after we engaged the fire department, they indicated that, well, based upon this, there are going to be certain additional requirements above what we look at that's different than the standard. There has to be illumination of exit signs. There has to be a fire extinguisher. There has to be a secondary access point from the individual room. And the only way we can add all of those standards is to.
Okay, and this is my last question, Mayor, and I'll be quick with it. So why not just eliminate rooming houses within the city? I think this also sends a message that we're technically, rooming houses are acceptable in the city of South Fulton. And that's not the message that we necessarily want to send out. Again, I in my opinion. So what I think enforcement is the issue, but that's my last question. Why not just say rooming houses are not allowed in the city of South Fulton versus having to say we are, moving in the direction of we do accept rooming houses, but you have to do this, this, and this, and this, and this. And I'm done with my questions.
Sorry, that's a good question. And so my quick response would be, because we have nothing that covers us, that protects the city for those types of short-term rentals or those types of rentals that go beyond 31 days. So right now, you could be engaged in short-term rental activities, but if you say that the occupant has been there for more than 31 days, then now that short-term rental provision in our ordinance does not apply. So the only other thing that we had that could cover us from both the 30 days or less or the 30 days or more was to add a rooming house use back to the ordinance, and then make both of those types of uses, short-term rental and rooming house, be subject to the approval and conditions of a special use permit. That would give us the ability to do public hearings and notices for the area, and then to eventually add conditions, at which time it goes to the public hearing phase of the process.
You got that?
Yes, Mayor, I'm done with my questions. Thank you for the opportunity.
All right. Councilwoman Willis?
So to be honest with you, this is a problem that has come into existence mainly in urban communities, Metro Atlanta wide. This issue is being taken up. There's a study committee being done in the General Assembly to figure out how to regulate this issue statewide. This issue has come up from residents making us aware that people have come into residential communities, investors have purchased homes and gone inside of these homes and created, as Mr. Hull stated, rooming houses, that place numbers on the doors. They have taken basements, put 4 and 5 rooms in the basements. And when you go pull the original plans of the building plans for people to get certificate of occupancy, the building plans are totally different from what they have gone and renovated. Mr. Hull and I had a meeting with over 50 residents. When this was brought to our attention, it started back in July. We've had 3 meetings with this particular community, but in this meeting, it was residents basically from districts 3 and the Old National Quarter, where residents have come in and complained about investors coming in, purchasing homes, and basically turning the homes into residential communities. We have had to work with our municipal court to get basically warrant to go in and inspect a particular home in the city, in my district, and we went in and found basically the house was turned into like a hotel. And so what I did is I did some research and found out information from a Georgia Municipal Association meeting from another council member in another area of town that was having the same issue. And they had to put conditions under their short-term rental property. And I went and pulled the information. I actually requested the information from the city of Doraville. And the clerk sent me the information, sent me the legislation. I sent it over to our city attorney office and also sent it to our CDRA office. And we worked for months to try to come up with what we could do legally that would not be a violation of the Fair Housing Standards Act, and what we could do legally to protect our residents. This text amendment is what we have come up with. It is a way for our city, number one, for companies that come in under the auspice, well, I won't call a specific company, but one company name I can text to you. Councilmember Gums is very popular. They have several, they have gone in mostly districts 3, 4, 5, 6, and created these type of models. And code has gone in. And so to say that code should be more, they have gone in, but their hands are tied because these companies have found a loophole in the short-term rental policy, in our short-term rental policy, and it has left us exposure. With this text amendment now, it will help us regulate it better. They will have to come before the council for a special use permit. They will also be subject to inspections to make sure that they're in compliance with our fire code, our zoning code, and also the council will have an opportunity to have the plans be submitted before council and determine if you want this type of activity in your area. It has been horrific to some communities, this type of model that has come into residential communities and caused a lot of havoc because you don't know. Number one, we have in our zoning code that we're supposed to only have 4 cars in the driveway. Well, if you have a 4-bedroom house turned into a 10-bedroom house, and mostly of the people who are renting in these homes have cars, then you're going to have more than 4 cars in the driveway. I have had complaints of people complaining about trash being thrown all in the yard. I've heard have gotten complaints of crime incidents happening in the yard. So this is a way for us to be more proactive and less reactive. And because they have found a loophole around our short-term policy, they don't have to register like they do with the what do you call the what's the concept when you rental? They're not registering. They're just building, they're going in, purchasing these homes, they're doing the renovations, and they're turning these homes into what the most popular name is split pads. And I found out about it through residents bringing it to my concern. And several residents have been coming to the council meetings for a while complaining about this issue. And I actually went to the site, looked into the situation, had the certificate of occupancy pulled, looked at what was submitted for these investors to get a certificate of occupancy, and it's totally different from what they are doing, how they are renovating these houses into basically hotel rooms. So this is a necessary step that needs to be taken to give us to make sure that this does not continue to happen without regulation. The Planning Commission, and what before the Planning Commission, they heard and they unanimously approved and agreed to this. And I think it will make our residents who are being violated in the residential communities feel a lot better that we have this type of protection in place to help regulate this new housing phenomenon that is now taking place throughout Metro Atlanta. And I was trying to get something in place before something goes through the General Assembly that will prohibit us from doing this. Thank you. And I move, wait a minute, before you recognize, I want to move that we approve this measure. And then I know you can still have discussion, Mayor.
Okay, it's been moved. Is there a second? All right, hearing no second, that fails for lack of a second. Dr. Rao?
Thank you for recognizing me. I have a couple questions. A lot of great information was shared. I actually like a number of the concepts as it relates to strengthening our ordinance for short-term rental, but I would also agree with Councilwoman Gums, who, and I agree with her. I don't think we should allow rooming houses, period, in the city. And so there are elements of both things that I really like. I'm just not totally sure what this means because we have a number of them who have already registered as short-term rentals. Is it some provision where we can make them come into compliance, within 3 months of adoption or something like that, as opposed to ones that would be licensed afterwards? Those are the kinds of questions I have. I would definitely support, no rooming houses in the city, period. 2, regulating the ones that's short term by, like you said, putting all those conditions, making sure all those things are in place. And since we already have some license, can they come in compliance within a certain period of time?
Councilwoman Rowell, I'll attempt to answer many of those questions you have, and those are all very good questions. As it relates to those that can come into compliance, in our ordinance, and again, this is to the credit of Mayor and Council, there are stipulations that that short-term rentals have to comply with. And in fact, I think they have to comply with by December 15th of every year. So right now, if you are operating as a short-term rental and in preparation of this, I wanted to make sure that I had contacted the finance department through the business licenses division to even understand how many do we have in our city. So there are approximately 50 or so legally established short-term rentals based upon the code, the current code. So that kind of answers that question. And so, but the challenge has been the ordinance, as in anything that you do, at some point you have to look at the ordinance to look at the validity and look at the applicability based upon today, not last year, but today. So this evolution of shared housing concepts has now changed. And unfortunately, many cities have not kept up with the change. So what this is proposing to do is to now further regulate the short-term rentals. Now, our approach to deal with, because keep in mind, short-term rentals are only for those occupancies that are 30 days or less. So then the question becomes, what happens if you're 31 days or more? Right now, we have nothing that governs that. And so because we have nothing that governs that, these things will be permitted by right, subject to them getting a certificate of occupancy. And we have no way of tracking them. Nor are they required, and I mean the entities that are short-term rentals, nor are they required to provide us with a list of their occupants on a monthly basis. So we don't know how long the tenancy of a particular person is in a residential unit. We just have to go by what they're, we have to go by the honesty measure and saying that, okay, you're given this license to operate as a short-term rental. You cannot have occupants there more than 30 days. We do inspections, they do pay a fee, and there are some requirements in the current short-term rental ordinance that talks about, first offense, second offense, third offense, attributed to if there are conflicts with the individuals residing in the properties and there being complaints that are received by the city. But outside of that, if you basically check the box and do everything that you're supposed to do, you could be granted a short-term rental license. What we're saying is, let's take this up a notch because of some past practices of short-term rental operators. Let's take it up a notch because we have repeat offenders. And so to do so, we're now requesting to have a special use permit. And if I can just take a moment, and I don't think that the city of South Fulton does it often, but special use permits are by and large those types of uses that at one point in time may have been approved. They may be amenable for the area. They may be those types of uses that are appropriate. But because of changing dynamics, you have a special use permit now that allows you to, instead of one point in time, it allows you to look at it under these special conditions, under these special uses. And so as a result of that, I've not seen it done in the city of South Fulton, but special use permits can be granted for a time period. It can be granted for a year, 2 years, 5 years. The intent is that when you add time limits and then you bring in the provisions of special use permits, you are then allowed to really fully analyze the proposed project as it relates to the immediate environment. So just imagine for a moment, if you bought a house in a subdivision and you were not aware that your next door neighbor was going to rent out all the bedrooms, all the living spaces, convert storage areas, and rent out the patio as bedrooms, imagine that you would want the city to encourage and enforce stricter development standards. With our current process, we don't have that ability. So what we're saying is the special use permit allows us to look at all the factors related to the location of the house and its environment to look at the distance between the next house, to look at the amount of driveway space that's available for people who may be coming in, to look at all of these factors in totality, along with the fire safety provisions that we know are required because the occupancy load now has changed. It's gone from what we thought to be a 5-person house or a 6-person occupied house to now 12 people or 15 people, depending upon the size of the house. And that changes the whole dynamic in terms of how we approach and how we analyze the particular project. And so taking all that into consideration and understanding that short-term rentals are only for 30 days or less, we need something that's going to protect the city for what we now see is a growing trend to have longer contractual agreements that go beyond 30 days. Because some of these major corporations have examined our short-term rental policy, as they have in many other communities in Metro Atlanta and most in metropolitan areas. And so they're now tweaking their model. And thank you, Chief. They're tweaking their model so that now they can get around the provision of 30 days or less. And that's where the rooming house use provision comes in, which, by the way, is still subjected to, as we're recommending, a special use permit, which in the context, see, what we're missing here is when our short-term rentals are approved, we don't have the luxury of having this distinguished body and the Planning Commission to go through and identify all of the potential issues which may occur because it's approved administratively. And they've taken it, the business operators have taken advantage of that administrative process. So now we've kicked it up to a public hearing. We've cooked it up to a special use permit. We have all the departments now looking at this, and we're regulating it as best as possible to make sure that we have considered every avenue which they might try to get around. And I'll conclude my conversations.
Point of order, Mayor. Your thing is on mute.
Yes, Councilwoman Willis.
I received a text, and it's in the chat, where Councilmember Pritchard did second the motion. I just want to bring that to your attention because you did make the announcement that my motion fell for lack of a second.
All right. We're in discussion now. I'd be happy to entertain the motion. There are some people that haven't spoken. I haven't spoken, and we haven't heard from Councilwoman Pritchard herself and Councilwoman Williams.
Thank you, sir.
I will entertain a new motion.
Okay.
I do want to follow up, Mr. Hull, with some questions that, in the same vein that Councilwoman Gums asked about. We previously, and I don't know if Ms. Dingler or someone from fire or code enforcement is available, but under the previous ordinance that Councilwoman Gums originated, we did not necessarily have enough inspectors to go and do fire inspections. One of the stipulations of the original ordinance is that they had to get a fire inspection done. And my understanding in speaking with fire is that there is a different standard of fire alarms or extinguishers that are needed when you are operating basically an Airbnb out of your house. It's not just like you got to have one fire extinguisher somewhere. So I just want to understand who will be doing. Are we contracting with a private company to do these inspections, or are we just expecting that the current staff that we have in place is going to be able to conduct all of the inspections for all of these new applicants.
So I don't, Chief Jones isn't here, and I don't know if Ms. Dingler is here, but what I will say is that based upon the required inspections per the change that we're requesting, that we will pass those costs off to the applicant. So whether it be our city staff, whether it's done on overtime, whether it is done by a contractor, whatever the case may be, we will have to pass those exact costs to the applicant. I don't know that we have necessarily discussed internally with Chief Jones who is going to be, but part of, again, as we consulted some of the departments, they thought that elevating this up to the next level would be critical, understanding that particularly the fire department has an important role to play related to public safety, health, and welfare.
All right, well, thank you. Chief Jones is here. So, Madam City Manager, if it's all right, if we could hear from him or Chief Moses.
Yes, that's fine, Mayor.
Okay. Chief Jones?
Yeah, good afternoon, everybody. Yeah, I'm on this. Chief Jones. Yeah, we had talked a little bit, and really it's going to be data driven. So as these properties come on, as Mr. Hull was saying, and we will inspect them, we'll put them in order, and then depending on how many we are having to inspect, along with commercial buildings and other, will drive if we need more personnel in the future. But it's just going to be data driven as far as how many people we need, how many people sign up. But it is imperative that we get this done and we get them inspected, because of the fact, like you just spoke of, it becomes kind of a commercial property, which falls up under, state law. And if someone gets hurt, we need to make sure as a city that they're following the rules.
All right, thank you. I would, I would ask, usually we have fists when we bring things before council for a vote. And, I would just like to understand what we think it's going to cost to actually implement what we are passing. I don't want us to pass something that is, that is toothless, because we haven't, we don't have the resources necessary to do the implementation. And my last comment for now is really just amplifying the concerns that Dr. Rao and some other people have made. I am personally a little concerned with how many things are becoming special permits. It's beginning to feel like we've said as a council and as a constituency of residents, here are the things that we don't want in our city, and they all seem to be just becoming special use applications. And I am not. I want to ensure that we have if this is going to become a special use application, that there is a very clear rubric that explains when we're saying yes to something versus when we're saying no to something. I don't want to get into this place where our no is being challenged because the rationale behind it just seems capricious and not that there's no rhyme or reason to it, and that the courts might look at that, and that is just my concern when we have so many things going through a special permits process. If there were some way to identify areas on our future land use map where we were going to allow these sorts of things, and they were confined to an area, or if they were confined to a certain number of months or a certain number of people or a certain number of square feet, but it just seems like we're opening a Pandora's box where anybody will be able to come and ask and turn their house into one of these things and then we're left explaining why we said yes to someone and no to someone else. And with that, I'm going to turn it over to Councilwoman Pritchett.
Thank you, Mr. Mayor, for recognizing me. I would like to second Councilwoman Willis's motion. I would like to offer a friendly amendment for her consideration. And here is my question. I do understand that when a person stays in any residential property or any property for over 30 days, they become a tenant, like a tenant at sufferance, perhaps. And the city attorney can confirm this. So what I want to make sure is that these people are treated so that it doesn't become a rooming house per se, that these people would be treated similarly as they would if they were at a hotel, where if you stay beyond the time that you have agreed per your contractual agreement with the dwelling, that you are to be, that you should be removed. So my concern is enforcement, making sure that there is language that the owners of these dwellings in their contracts, that it's clear that anyone who stays, when they approach day 29 and reaching day 30, they cannot assume being a tenant by virtue of holding over for 30 days, and that at that point that as Councilwoman Willis has included here, that their licensing will be revoked, or that they are required to immediately initiate a dispossessory or eviction process so that they cannot just squat in these type of dwellings.
If we can, she asked if that could be a friendly amendment, Mayor, so I would like to respond since I'm the maker of the motion. If that is legal, I don't mind putting that, accepting that as a friendly amendment. It's my understanding, Mayor and Attorney Hyman, that if their inspection is done and the person is not in compliance with our code, that the certificate of occupancy is revoked. And I'm not really sure what that process is. Mayor, would you allow CDRA Director Hull to explain that process? Based on what the friendly amendment has been made, and I'm back in the queue once when you get finished with everybody else, recognizing everybody else.
Okay, Councilwoman Williams was actually next before you began, but
no, it was a friendly amendment made by Councilmember Pritchett, and as the maker of the motion, I had to respond whether I accepted the friendly amendment. And what I'm simply saying, Mayor, I don't, if it's legal, what I'm saying is I don't mind accepting that friendly amendment, but it was my understanding that when they go in and do inspections, if they found something that's not in compliance, the certificate of occupancy is revoked. And if that's the case, it may not be necessary to accept her friendly amendment. So that's why I was asking you if you will allow Mr. Hull to respond to that.
Mr. Hull, would you like to respond to that?
Yes, thank you, Mr. Mayor. And the question, one of the issues I think that the Councilwoman Pritchett mentioned were contracts. And that's part of the challenge, Councilwoman. We are not privy to, nor do we see, nor has it been a part of our practice to even review these contracts. To the point that we have a short-term rental ordinance, there are some provisions that the proprietor has to follow. Fill out the application. There are a couple of inspections. There are some fees that need to get paid. And typically this right now, as I recall, the short-term rental ordinance, because again, staff, Councilwoman Willis, to her credit, directed us to look at another municipality. We spent a great deal of time reviewing the short-term ordinance. It is permitted right now in all residential zoning districts. Right now, short-term rental ordinance allows for that type of use to be available. What we're saying is we're upping the ante to say, okay, absent of kind of knowing the contractual agreements, which is what you mentioned, we know that we've received complaints, and we know that in 1995, when this was built as a subdivision intended to be for single family, in 2022, that family dynamic has changed. The economic model for that household may have changed. Now that individual may just be seeking to rent out rooms, or may want to sublease rooms to one of these rooming organizations. And I won't specifically call names, but I think we've heard of plenty of them. What this does is it allows us to have provisions for that short term by our definition, and what would be considered long term or longer than short term, if you will, 31 days or more. And it kind of encapsulates all of that by having this special use permit to then really begin to analyze and drill down on the particular request. And Mr. Mayor, that also goes to the point that you were making about, not being capricious and arbitrary in terms of what we're doing here. The purpose of the special use permit application is to say at one point in time, and a classic example that I think everyone would understand is along Fulton Industrial Boulevard and having a lot of industrial uses. And now we understand that with the heavy industrial might of Fulton Industrial Boulevard, certain types of uses like residential will not be permitted. But in the event that there is something that could possibly coexist, we would have to do it under a special use permit, because the sheer nature of the area, which once may have inhabited or may have had residential development, no longer is predominantly has that type of use in place. And so a special use permit allows us to examine the features, examine the qualities, examine the elements of the particular request on the backdrop of what is there existing. And so that's what we're saying. The community has spoken as it relates to these are nuisances. We thought we were moving into single family residential. Now this house is being run as a hotel. We have cars that are parking along the street. We can't have our visitors to come, or they're parking on the front lawn. Whatever the case may be, the original intent of how we issued that C of O has now been violated, because now this has become an enterprise in and of itself, a business in and of itself. And now rooms are being rented out. Additional spaces within the house are being rented out. And it breaks up the makeup of what was traditionally supposed to be a single family subdivision. And I'll stop my comments there.
All right.
Mr. Mayor, with my question, I guess for Mr. Hall or for the city attorney, is in the event that this does become like a hotel and people are there and they are squatting or they are holding over, what mechanism is there for removal? Or is it, I guess for Mr. City Attorney, is it just the same mechanism that any landlord would commence in this type of situation?
Councilman Pritchett, from listening to Director Hall, the way, from my understanding, this particular legislation is working, we're seeking to hold whoever the property owner is that decides they want to change a residential dwelling into some type of rental model, that they would be the ones that the city would be looking to comply with this piece of legislation. And then to the extent that property owner had tenants, that property owner, the tenant, I'm assuming, would enter into some type of agreement, and it would be that particular landlord's duty to come into compliance with the city, and that would be up to including if they needed to reduce their occupancy, having something built into the lease to address that issue. I don't know if that answers your question, but really it would be between the landlord and any perceived rental tenant for his contractual documents to address that in the event if he's not complying with local or state law that, you know, they may have to leave or whatever those enforcement mechanism in that document would be.
Okay, so Mr. Mayor, I withdraw my friendly amendment and would like to just second Councilwoman Willis's motion as is.
All right. Thank you for that. So we have your second note and we're in discussion. Councilwoman Williams.
Yes, thank you, Mayor. My first question of two, possibly three, in those instances, Mr. Hall, where we discover that a property owner is in violation of their certificate of occupancy, what are we doing to rectify and remedy that? Because I would imagine that if they violated the certificate of occupancy, there has to be some recourse there to remedy the situation. And as a subset B of that question, if there's been outright deception in obtaining a certificate of occupancy, can it be revoked based on the fact that the application that was put in was potentially fraudulent?
Excellent questions, Council William, as usual. Excellent questions. So to answer your first question, you are absolutely right. And as a part of going through this analysis for this, when we were discussing the issue with our building official, he made it a point to say, Derek, we have to allow them time to remedy the issue. So the point that you made is valid. We can look at if there have been occurrences or any of the violations as outlined in the current short-term rental policy. But then we also can go beyond that because there are some residential codes and some building codes that also come into play. But if we just look at short-term rental, the answer is yes. We can cite them and then give them time to remedy the situation. Now, if they are legally permitted, then they are allowed to remedy the situation and then continue operating. To your second question, and this was the question in particular that occurred in District 3 in Councilwoman Willis's district, and that is there was clear deception from the start from the property owner. And when we did our inspection, after getting a court order injunction to go in, or I think that I'm saying that right, court ordered provision to go into the property to do a site inspection, we learned that nothing that was on the attached site plan that was approved as a part of the building permit issuance was what we recorded in the in the house itself. So all of the recreational space and storage space, things of that nature, have been converted into individual rooms, bedrooms, and there was evidence that people had been living there. And so we revoked that certificate of occupancy because it was deception on the part of the property owner that he or she was not honest when they pulled a permit to do renovations of their house. Now, these are the types of things that, and this is why it's important for us to have a robust community, because looking at it from a staff's perspective, we really wouldn't know that the person was basically leasing out 10 bedrooms in the house. And we later learned that the leases extended beyond 30 days based upon our investigation. And so then it's not even covered underneath the short-term rental policy anymore because it exceeded 30 days. So our thought is we have to cover traditionally short-term, and then that period that is longer than short-term, 31 days or more, we have to cover the city's position by making sure that we have coverage on both ends. And so that we're not so heavy-handed, because a use is a use. I mean, whether you're there 30 days or whether you're there 300 days, it's still the same type of occupancy use, regardless as to your time frame. And when a 30-day person leaves, another person will soon thereafter come after and occupy that space. So it's constant use the entire time. And again, I don't want to take anything away from any council member who had anything to do with the short-term rental ordinance. It's an excellent document, and we only had to embellish, if you will, add a little bit of lipstick to the pig and some brush and some blush to make it a little bit more prettier, a little bit more sturdier, so that it can address what today is now a change in the trends of how people are living through this shared housing concept.
Okay, thank you for that. And so that brings me to my second question, which is, does adopting this today preclude this council in any way from going in and taking a closer look at the issues that Councilwoman Rao raised? Because I do think that we need to put a sharper eye on the questions that she asked. But I also don't know that we need to let this linger, particularly given we're probably about less than 30 days out from the start of the next legislative session. So if we pass this today, can we then turn around and go back in and try to refine it even further in a later iteration?
Again, an excellent point, Councilwoman Williams. And I should acknowledge to you, and certainly Councilwoman Willis can attest to this. I made mention and in discussion with the city attorney and all of the departments that were a part of this. We wanted to do this as a first phase. I don't know if that language is actually contained in the staff report, but we mentioned to Councilwoman Willis that we wanted to do this as an attempt, a first phase, that we saw this being further refined, particularly as we began to see people react to what this new ordinance provision was going to be. We think that there is some additional further refinement down the road. So there may be an additional phase 2 of this refinement of this ordinance, and maybe even a phase 3.
Okay. Yes. All right. That answers I think the 3 questions that I had. So that, thank you very much for that. And I yield.
All right, thank you, Councilman Sebastian.
Thank you, Mr. Mayor. I do have a few questions here. First one is for Mr. Hull. You said right now these types of establishments are permitted by our current regulations. Are they actually permitted, or they're just not prohibited?
The short-term rentals are permitted, provided that you follow the ordinance and all of the provisions that are summarized in terms of what are the requirements in order to obtain a status to operate.
And that's based on the original ordinance that that Councilmember Gums said she sponsored some time ago, right?
Indeed, indeed. And that is administered through our finance department, our business licensing division.
Okay.
There are several stipulations that are included in that, but they are all approved at an administrative level. So they're approved by staff.
Okay. So in my mind, and bear with me for a second, I'm thinking about this as two different things almost, right? You have people who would come for short-term rental and they stay, they don't disrupt the neighborhood, and then they're gone. And then you have other things that might happen, another client that may come in and they may show up with 10, 12 people, right? And 10, 12 cars. And they would have a more adverse impact on the community that they show up 10, 12 people, 10, 12 cars. Are there any stipulations anywhere? I couldn't see anything around parking, or the number of cars that's being regulated. And we all know that's a problem in our community, right? I didn't see anything at all. Was that looked at while we were looking at this thing?
Yes. And that is where, Council Member Sebastian, that is where the special use permit comes in. And if I can just take you back to a moment in time, I think in Councilwoman Williams' district, we had a special use permit for a salon suite. If you recall, I want to say back in November council meeting. The reason why I bring that up is the special use permit allows the staff and the city council and the planning commission to add conditions. If it's administratively approved, technically you should not be adding conditions to the land use entitlement because it's not considered discretionary, if that makes sense. So what we're recommending to strengthen the already existing policy, because we've had these impacts to the community, not just with parking, but maybe even some bad behavior. There may have been instances where we had to send out emergency services. And if it's not well known that this is a property where people are renting out rooms, there could lead to a lot of confusion in terms of how do you get in contact with the property owner. For instance, all of these, so having a special use permit allows us to have the conditions that we'll talk about, the number of parking spaces that are required based upon the occupancy load. The mere fact now that this may be built as a single family house, but we have to treat it differently because the occupancy now is different.
Right.
This week it might be 8, but next week it might be 15. And that's where our fire department has different requirements based upon the changing occupancy load. I mean, it literally is run like a hotel.
And this kind of brings me to my last couple of questions. First one is, given the type of establishments that these seem to be, and that the example you mentioned in D3 was that people went ahead and did stuff to the building different than what they were permitted to do. Why are we using a 2-year inspection period rather than a 1 year, or even if it's legal, make it that we can do a random inspection of a property? And secondly, speak to the current properties. How would they be grandfathered, if in, or will they have to immediately apply for a license or permit? And how long do they have? Because I didn't see anything at all in the document that speak to those.
Right. So let me take the grandfathering clause in first. Those short-term rentals that are approved, are permitted legally, as long as they continue to follow the existing ordinance, they will be grandfathered in. I will remind you that we did look at this existing ordinance, and there is a deadline by which, if you are a current short-term rental business, you have to apply for a new license by a certain cutoff date, which, if I recall, was December 15th. Now, we also look to see how many currently operate. There are around 50 that operate legally as short-term rentals. That's the number that I got from our business licensing division. And so as long as they meet the requirements as outlined in the current code, and that section of the code is not going to change, they will be allowed to operate. But any new ones coming in, should this council consider these items before you, they would have to go through the process that we have just identified with the special use permit, subject to the inspections, payment of fees, and then the inspections every 2 years. The reason why we didn't request annual inspections is just because of the capacity, understanding what the fire department and the building department currently have on the books. Even 2 years is a little aggressive, but we thought if we needed to maybe contract these services out, we could come back to council to say, you know, we're committed to doing these inspections every 2 years, but because of the limited man hours we have internally, we have to make sure that we have some additional assistance.
Honestly, I would have loved to see a clause over a random inspection between those 2 years, but that's just me. All right. I think that those are all the questions I had. Thanks.
All right, Councilwoman Willis. And I'm sorry, before you go, Councilwoman Willis, I do see Fire Marshal Donna Dingler in the queue.
Good afternoon. I've been able to listen to some of the comments that each and everyone's made. I'd like to make a few statements. First of all, the short-term rentals that we have in existence today, Fire has, because we have a requirement of a business license, which gave us a right of inspection. A short-term rental, we haven't had too many issues, but when you start expanding that out, when we're talking about single family residential homes, I've had numerous homes because once 3 or more people who are not related to each other, we're now looking at a boarding situation. I've had illegal homes being used illegally for personal care homes. I've cautioned us with that because we're looking into one on Cascade. It takes a lot of process to report to the Department of Family Children's, the Adult Services, getting those people actually moved from a place. And, you know, we have plenty of people out there soliciting people who are challenged both physically, mentally, and, you know, into these boarding type situations. If there are more than 6 people, that home would have to be sprinklered. And, you know, just like because it's more than just a permit, and it getting to the rights of entry. The fire department has the problem of we don't inspect residential homes until we have a legal basis, such as having them have a business license. They're operating as a business. We've closed down numerous illegal personal care homes where someone takes a single family residential home, divides up, you know, the rooms, and then they go and solicit to have people put in there. It is absolute a horror for adult abuse, in my opinion. So we do have to look at this from that standpoint of, like Mr. Hall said, we look at it by use and occupancy, and the rules change the more number of persons that you have. So unless someone's willing to sprinkle their home just to have 6 people in it, because we already have single family homes that use that relative policy pretty leniently too, and have, I mean, I don't have to remind anybody, in October, I had 10 people loosely related to each other, and 4 of them died in a house fire. So those are the type of situations that I would want us to be due diligent in looking at the fire code, looking at how we proceed. And I'm going to be honest with you, I can see it. To get someone who illegally decides to stay after their term has to go through a full, pretty much eviction policy. I mean, the whole process. So it could be greater than 90 days to evict someone who may be illegally staying even after their contract is out. So those are some of the situations that I see. I'll be glad to go over anything with anyone, show the life safety code rules. We can talk about the international fire codes and how we apply those. But, it's a sticky slope because the fire department is out there. We're discovering them every day. I've got one now that we're working on Cascade Road, and getting that legal right of entry. Can code enforcement go in? Can how much can the fire department do? Those are some serious issues that as we look at this before we make quick decisions, we want to look at it to make everyone safe and to not be, to not bring more issue upon people's, endangering other lives, because that's kind of what's been going on. People just want to rent out a room. And I'm sure there's a lot of this going on illegally now. But if I can help and assist or provide any codes to any of the council, I'll be glad to do so. Thank you, Mr. Mayor.
Thank you, Chief Dingler. Okay, Mr. Adams has let me know in the Novus queue, we have Rowell, Gums, and then Willis. Councilwoman Rowell.
I'm sorry. I was just trying to think about some of the comments I heard Fire Marshal Dingler make, and it actually left me probably a little bit more torn. I want to make sure I understand her comments in particular. Is it her concern that we may not have covered all of our bases, or that there are other parts of the code that allow you some flexibility to go in and address some of these issues?
It's my concern that we may not have enough right of passages to inspect all these places, because unless they get a business license, then we have no right of entry. Unless we catch them, and if we catch a home, like I was talking about the illegal people boarding, I literally have to make complaints to DHS and so forth related to the type of people they have, and it takes time. So those are some issues that we've been facing.
So follow-up question. So you're saying if we at least move to this and they be required to get a business license, then you have more latitude to go in and do these inspections. And maybe what we may not need to deal with is the 2-year period, because you could go in as you need it because they have a business license.
That's correct. It would give,
okay.
Requirement of business license would give both code enforcement and fire a greater right of entry.
Okay. Well, if that's the case, I'm getting more comfortable, and it seems like maybe we shouldn't tie our hands with the 2-year piece, so that if they could deal with it, go in at any point and inspect if they had to. Would that be is that correct? Would that be your preference? Let me say that.
I would think so, because what we're trying to protect is the solicited tenant that may be being taken advantage of, and we're trying to protect the conditions that we see in these homes, which some are very atrocious, and to be honest with you.
Thank you. That I don't have any additional questions, and I will say, I think some minor adjustments, and we're going to have to recognize that we may have to adapt at some point, may make sense. I am sensitive to the fact that the General Assembly is going into session, and this has been a topic that's been brewing for a while, actually. And so I want us to have some level of protection and and we can tweak as we need to.
Awesome. Councilwoman Gomes.
So, all of the questions and the responses have been good and eye-opening. I just have two actually questions. Was there any reason why we could not separate the two? Because we're talking about short-term rentals, right? But then we're saying that these are places that people are possibly renting out over 30 days. They're becoming personal care homes, or however the case may be. Is there any way that we can, because how Councilman Sebastian has shared his point of view, it does look like two separate issues. So I was just wondering, have we ever thought about, could we have done it a separate legislation and maybe put in a clause in the short-term rental, specifically saying that, there's additional language for rooming houses or split pads, etc. I'm very sensitive to knowing that the General Assembly is about to start, but also too, I'm also sensitive as well to about these individuals, not just the personal rooming houses, but with the legislation for the short-term rental, we're saying that everyone has to come in and get a special use permit, and then it has to come in front of the council to get approval. So certainly these people that are following the short-term rental, they paid their money for the business license. Most of it is time sensitive. I don't understand how, if they have met the requirements to facilitate to get a business license, to get approval with the inspection, and they are to commence to, rent out their home versus on Airbnb or VBRO or something like that nature, that each time do they have to come and get a certificate of occupancy? I mean, that seems cumbersome, and it also seems like another extra layer that, these people will not be willing to come into compliance. They'll still continue to do it illegally. So that's my two questions. I don't know, Mr. Hall, if you can jump in.
Oh, absolutely.
Answer those questions.
Absolutely. So as it relates to, let's just take the rooming house uses, or even if you want to take away that word, right now we have no ordinance in place that governs anytime a person is staying at a place. And when I say a place, I mean a place that has been designated as a business enterprise. We don't have anything that governs that right now. There's nothing in the way that will protect the city. And that is what Councilwoman Willis was talking about that occurred in her district. That there was a business, and there are others in the city that we just have not found out about. But we had this particular use that was not, by and large, classified as a short-term rental, because the entity that was running it was doing annual leases for a bedroom. Now, I won't name the entity, but that's what they were doing to get around, to circumvent our short-term rental process.
So I'm sorry. Just we've talked about this for a minute, so I do just want to hop in. You're saying that these people, I think the agreement that we've come to is that in the instance that you just described, those people would have to come and apply for a business license, which they would have to reapply for annually. And every year, when they get that business license, there'll be an inspection of the property. Is that what we are all agreeing on now?
No, that is not what we are agreeing upon, but you didn't let everybody finish their discussion.
Okay, Mr. Hall, could you explain?
Sure. So in that instance, this particular property in District 3 did not go through a short-term rental process because the tenancy was longer than 30 days. So they went through no process. Why? Because the city has no provision currently that considers uses this type of business enterprise beyond 31 days, 31 days or more.
I got it. So now they would, according to Fire Marshal Dingler, they now would apply for a permit. Is that correct?
Correct. And so getting back to Councilwoman Gumb's question related to the business license and those that have been operating in accordance with the ordinance, and what Councilmember Sebastian mentioned, they would be grandfathered in. They're considered good stewards. They are A students. They get to go on the field trip and others do not. It's those that have not followed the ordinance, Councilwoman Gums and Mr. Mayor, that we're saying, okay, you've had your opportunity to demonstrate to the city that you understand the ordinance and you adhere to the ordinance. If you choose not to, now we are imposing additional rules and regulations because we've had a number of complaints and a number of violators.
I guess the question though was specifically, how often do people have to reapply?
So they would still have to reapply under what we are proposing. They would have to apply for a special use permit one time. And then annually, as a part of the process, the business licenses would have to be renewed annually. That's what the process is currently.
And when their license is renewed annually, they would have an annual inspection.
That is not what we agreed upon. You didn't let us finish discussion.
Got it. So is there a suggestion for how often the inspections would be?
I was waiting to be recognized. Whenever you recognize me, Mayor, I can get. A simple solution to this all would be to accept Sebastian. A simple solution to this all would be accept what Councilmember Sebastian suggested from the beginning, and that is not to put a 2-year annual inspection in place. Let's just do random inspections, because according to Officer Dingler, that would give the fire department the right of entry whenever they get a complaint that this violation is going on in violation of our short-term rental policy. And the answer to Councilmember Gum's question, why wasn't this a separate policy? We have been working on this since August, and this is being done in violation of the short-term rental throughout Metro Atlanta. It is not to slight the Airbnb and VROs who are operating legally and who are registered, and it is not to slight your short-term rental policy that you put in place to regulate them. But what is happening is these companies are coming in violating the policy that you put in place. And we're finding out about this violation through residents who are complaining about these people coming into the community. And also, as Officer Dingler just stated, we're finding out about the violation of these policies through house fires, through lawlessness. And so all this ordinance does is strengthen and amend the policy to put certain provisions in place. When we found out about the house that happened in my district, we had to go through municipal court in order to even get right of entry for the inspector and fire department to go in and inspect the property. We had to go, it took us a month to get in that house. What this ordinance does is, with accepting Councilmember Sebastian's friendly amendment, is give these individuals the right of entry when they find out that this stuff is taking place. And of course, Mr. Hull recommended that we do a second phase. And so I just also would like to remind my colleagues that this stuff then we had a legislative process. So when it went through the legislative process, it's set in the legislative process for a month. Then it went through the zoning commission, because when we have text amendments, they have to go through the planning and zoning commission. So it had to go through 2 reads with them. And then it also had to go through, this is the second read from the council. So when we go through phase 2, it's going to go through all those steps. It took a month for this to even get through the legislative process. And everybody gets the emails and everybody gets notice of the planning commission meeting. And so all I'm saying is, let's go ahead and put this in place to protect us and hold the violators accountable. If we need to strengthen it even more, go ahead and send in your suggestions so that we can strengthen it even more. All I'm trying to do is protect residents who are being violated in their residential community. Some council members on here have also received the complaints. A former council member came to Burdette and she complained about this. She's been complaining about this for years, happening in District 5. So this is becoming a more frequent problem under the auspice of affordable housing. And when people move into residential communities, they don't want to wake up and go outside and find out that the house next door is being treated like a hotel room. And we have no ability to go in and inspect this is being done right now without going through all kinds of bureaucracy, as Officer Dingley just stated. So I do agree, Director Hull, on the friendly amendment that it needs to be a random inspection instead of, and that would solve the problem, because they already have to go through applying for an annual business license. They already have to go through applying for the normal annual processes. They already have to do that. The current short-term rentals that are operating legally. This is going to help us mandate the ones that are not operating legally.
Okay. It's
So
unfortunate.
if I can get a word in
I was not able
edgewise.
to finish my comments before, and I did not get the answer that I was needing from Mr. Hull before I didn't relinquish my time. So Councilwoman Williams, if you just give me a second.
I recognize that,
no,
Councilmember Gums. That's why I was telling the mayor that he didn't allow us to finish our discussion. And I did. That's what I kept saying, Councilmember Gums. So I apologize that you weren't allowed to finish the discussion.
Can get a word in edgewise, if I may be allowed to get a word in edgewise. And if the mayor would be willing to recognize me so that I can get a word in edgewise, because I'm not going to shout over everybody.
Well, Councilwoman Williams, I will relinquish I will turn it over to you as soon as I get my question answered from Mr. Hall. Again, I don't know. Councilwoman Willis began talking, and that was in conjunction to her conversation with the mayor. I just want to get my questions answered. I don't have an issue with the policy. I was just asking if there was another way of doing this. I do believe that there are several council members that have also began or tried to champion this. We have known that this has been an issue for quite some time. I know Councilmember Reeves, and I do know myself, have reached out to our attorney's office to try to figure out ways that we can get around it. So, Councilwoman Willis, thank you for pushing it through. But my question again to Ms. I'm not sensitive about anything about the short-term rental or being slighted for anything, because we're doing what's best for the community. I want to make that very clear. But I want to make sure that we're doing it in proper and in decent and in order. So again, Mr. Hall, are we saying that anybody that wants to operate a short-term rental or VBRO, new people that are applying will have to obtain a special use permit and go through a certificate of occupancy approval from the council before they begin operating their Airbnb or VBRO?
Everybody that's been operating a short-term rental property, I won't use the specific names, but just a short-term rental property as defined in our ordinance, assuming that they meet all the requirements, they will be grandfathered in, which means that they are legal conforming at the time of this proposed ordinance amendment, and they can just continue to go through the process, which my understanding is every year they have to apply for a new business license.
Yes. But I'm speaking of anybody new, not the current. Anybody
new? Yes, anybody new, and anybody who does not meet, because there are some, and Councilwoman Gumbs, you're probably most familiar with this. There are some requirements that must be done at the end of the year, before the end of the year, in order to receive your business license certificate.
Yes.
And if those things are not done, then they are subject to go through a whole new process. And so we're saying everyone that is in compliance based upon the existing ordinance will be grandfathered in. Now, we will still require, obviously the inspections, and they will still be subjected to the, first, second, and third offense as is outlined in the ordinance. But anybody new coming in will have to comply. Should this council approve staff's recommendations, would have to apply under this new process.
Okay. Thank you for answering that, and I'll yield to Councilwoman Williams.
Thank you, Councilwoman Gomes. Two things. One observation and one / comment, and one not. To the extent that we get these things in the legislative queue and we see them on paper, and yes, there are meetings, those things are not a substitute for debate by a deliberative body on the merits of what is being proposed. And each person has the right to ask their questions, to get their questions answered, to offer comments in equal measure. If we were in fact observing standing rules of order, each of us would have the opportunity to speak to the issue twice. And how we choose to use our 2 times to speak is on us, but each of us have that right. And so I think that it does us a disservice as the deliberative body. I think it does the residents a grave disservice to continually attempt to cut off debate and discussion when people are trying to raise questions that either A, we need to have answered in order to make an informed decision and a vote, and to confidently vote, and to B, ask questions that we know have come up in the community, because as has been stated, not only do we have these in District 6, I have one across the street from my house. So I'm intimately familiar with the issues. That does not preclude me from having the right to ask questions and to offer comments, and to do so unimpeded and without being browbeaten and chastised. And having said that, I move the previous questions.
Second.
I'm sorry, Councilman Reeves, I know you haven't spoken once, but
yeah, to move the previous question out there is going to end debate and go into a vote, and and I'm not inclined without having these particular questions answered. So go ahead and move on it, and if I'm not allowed to speak, and so motion was and second and put on the floor.
All right, so the motion has been, there's a motion and second to move the previous question. Mr. Clerk, will you call the vote?
It's a roll call vote. Councilmember Rao.
Yes.
Councilmember Gomes.
Yeah, that's fine.
Councilmember Willis.
Yes, that's fine.
Councilmember Sebastian.
Yes.
Mayor Pro Tem Reeves.
Nay.
Councilmember Williams.
Yes.
Councilmember Pritchett.
Nay.
The motion to call the question is approved 5-2.
All right, Mr. Clerk, please call the vote.
I'll repeat the motion as I have it. I have a motion by Councilmember Willis, seconded by Councilmember Pritchett, to approve the zoning ordinance text amendments. There
With
were
a friendly amendment. There was a friendly amendment.
okay. What was the friendly amendment? I had
Sure.
go ahead.
I
So-
had recommended removing the 2 years. I know you said it. That was actually my recommendation.
Yes, that was actually Councilmember Sebastian's original recommendation.
He raised it. He raised the concern.
The recommendation was to remove the 2-year inspection process to a random inspection process to allow for right of entry.
Okay, so noted. I have that. Okay. You ready for the vote?
Sure.
Councilmember Rob,
Yes.
Councilmember Gums,
Yes.
Councilmember Willis,
Yes.
Councilmember Sebastian.
Yes.
Mayor Pro Tem Reeves.
Nay.
Councilmember Williams,
Yes.
Councilmember Pritchett.
Yes.
That item is approved 6-1 as amended.
All right, thank you. I will just note that there are some other conversations about rental regulations, and so we will be visiting this at a work session to be determined by the city manager, hopefully by February. Mr. Clerk, please sound the next item.
The next item is item 3 under agenda items. It's a resolution approving the lease of real property located at or near 6095 Boatrock Boulevard. Would like to note to Mayor and Council that you should have received a number of emails with contract documents from the city attorney's office. And with that, I will turn that over to the city attorney or city manager for explanation.
I'll step in real quick. Per council's being informed at the last meeting executive session that there were 3 remaining issues that needed to be hammered out or hashed out with Jacobs. And literally at roughly 1 today, we had some further communications leading all the way up to this council meeting and finally got the approved clean version back from Jacobs council. And so that's why it was a last minute flurry. And because the sublease references the master lease, I had them send over a copy of the master lease so that the sublease and master lease can travel together. So it wouldn't make sense to say that if you want to read what the terms and conditions of the master lease without it being attached. And so that's what's before you is the sublease that has been approved by Jacobs, as well as the master lease in which it refers to for council's consideration. And that's for the Boatrock facility.
Thank you, Mr. Hyman. I do see on this sublease, the first line mentioned is CH2M Hill. Should that read Jacobs? Or is that?
That's what they have on this for the council. I guess as it was originally contemplated a master lease, they referred to CH2M Hill, but that's they approved this version of the sublease from the council.
Okay. I see Councilwoman Willis in the queue. Is that from is this from the previous?
Yes, that's from the previous discussion.
All right. Well, seeing no hands raised, I will entertain a motion. If there's no further.
I move that we accept the lease as presented.
Second.
All right, it's properly moved and seconded. Any discussion? I do just want to be clear. This will be for the public works facility. Is that correct?
That is correct, Mayor.
All right. Seeing no further questions, Mr. Clerk, please call the vote.
The roll call vote to approve. Councilmember Rao,
Yes.
Councilmember Gomes,
Yes.
Councilmember Willis,
Yes.
Councilmember Sebastian,
Yes.
Mayor Pro Tem Reeves,
Aye.
Councilmember Williams,
Yes.
Councilmember Pritchett.
Yes.
That motion was approved unanimously.
All right. Thank you, Mr. Clerk. I believe. Please sign the next item.
Next item is executive session concerning real estate.
All right. I will entertain a motion to go into executive session.
I move we go into executive session for real estate.
Second.
Been properly moved and seconded. Mr. Clerk, please call the vote.
Roll call vote. Councilmember Rao,
Yes.
Councilmember Gomes,
Yes.
Councilmember Willis,
Yes.
Councilmember Sebastian,
Yes, sir.
Mayor Pro Tem Reeves,
Aye.
Councilmember Williams,
Yes.
and Councilmember Pritchett.
Yes.
We are recessed for executive session at 3:55 p.m.